Ladies and gentlemen, welcome back to a brand new legal breaking reporting video analysis update for the evening of October 20, 2025. Tonight's reporting, we have October 21, 2025. Tonight's reporting, we have two major legal breaking updates. The first one is Lindsay Halligan is being considered by an appeals court to weigh whether or not she is a lawfully appointed United States attorney. She's not, because Trump never got her confirmed by the Senate, nor did he get permission from a judge to extend her temporary appointment. The second one is Trump is pushing for his Justice Department to illegally give him $230 million in exchange for supposed drama bullshit that he supposedly received from being prosecuted because of all of his crimes that he committed previously. Let's get into this first reporting by the New York Times.
Appeals court weighs whether Alina Habba is a lawful U.S. attorney. This article is by Jonah E. Bromwich and Tracy Tully, and read by an automated voice. A federal appeals court on Monday considered whether Alina Habba, a former personal attorney to President Trump, is lawfully acting as New Jersey's top federal prosecutor in a case that could help clarify the limits of a president's power to keep U.S. attorneys in office without Senate involvement. In August, a district court judge ruled that Ms. Habba had been acting as U.S. attorney unlawfully, plunging a struggling New Jersey court system into disarray and placing the work of the federal prosecutor's office there into a novel form of legal limbo. The judge, Matthew W. Brann, found that Ms. Habba's interim tenure had expired in early July and that she had not lawfully become the acting U.S. attorney, despite what the Justice Department had said. The department appealed that decision, and in a Philadelphia courthouse on Monday, 3 judges from the U.S. Court of Appeals for the Third Circuit bombarded one of its lawyers with questions while Ms. Habba watched from the gallery. Ms. Habba is one of several U.S. attorneys who have remained in power after their 120-day interim tenures expired. In each case, the Justice Department has taken extraordinary measures to keep its favored prosecutor in charge. The fundamental disagreement in Monday's hearing was over whether those measures were legal. The stakes are high. If the judges find that the government had the authority to act as it did in Ms. Habba's case, it would give President Trump enormous latitude to keep U.S. attorneys in power, regardless of whether they are confirmed by the Senate. The strategy is part of a broader pattern that has allowed Mr. Trump to take closer control of the Justice Department than any president in the past half-century. On Monday, the Justice Department's lawyer, Henry C. Whitaker, sought to convince the judges that the moves the administration had made to put Ms. Habba in office were not only lawful, but normal. The administration, Mr. Whitaker said, had taken precise and precisely timed steps, not to evade the law, but to be scrupulously careful to comply with it. Mr. Whitaker's fundamental argument was that the law grants the president numerous ways to place a desired official in office, and that the Justice Department had availed itself of those methods. The lawyer Abby D. Lowell, representing defendants who have challenged Ms. Habba's legitimacy, disagreed. The government, he said, had constructed a means by which somebody never has to be nominated and confirmed and can serve all the functions of a U.S. attorney forever. He said that the administration had cobbled together a chimera of 7 different statutes, which it cited by turns, depending on what it was trying to accomplish. The judges, too, appeared to find the government's position dubious. They frequently cut Mr. Whitaker off mid-sentence to pose additional questions. One of them, D. Brooks Smith, said that the administration's maneuvers in New Jersey seemed to him a complete circumvention of the Appointments Clause, a law that governs the ways high-ranking officials are selected and confirmed. For a time, the actual sequence of steps the Justice Department had taken to keep Ms. Habba in place went unacknowledged in the hearing, but when Mr. Whitaker described those moves as consistent with long-standing practice, Judge Smith seemed to object and insisted on reciting the facts. The judge then described in detail the moves the administration took in July, when Ms. Habba's tenure as interim U.S. attorney was set to lapse, and New Jersey District Court judges appointed her first assistant, Desiree Grace, to lead the office. The Attorney General, Pam Bondi, quickly fired Ms. Grace, and the President withdrew Ms. Habba's nomination to be permanent U.S. Attorney from consideration by the Senate. Then, Ms. Bondi appointed Ms. Habba to take Ms. Grace's position as first assistant, which, the government argued, automatically elevated Ms. Habba to the role of acting U.S. Attorney. At the same time, Ms. Bondi also appointed Ms. Habba to be a special attorney, overseeing the District of New Jersey. After reviewing this history, Judge Smith asked Mr. Whitaker whether he could name another instance in which such a concatenation of events has occurred with respect to the appointment of a U.S. attorney. "I guess I cannot," Mr. Whitaker acknowledged. He said, though, that the executive branch had undertaken similar moves in analogous contexts at other federal agencies. The judges also appeared to question Ms. Habba's resume. Though she had represented Mr. Trump in several civil cases, she possessed no criminal experience before she was appointed to lead the New Jersey office. One of the judges, D. Michael Fisher, said it seemed to him that Congress had sought to make it clear that an acting federal officer should be an experienced person. He asked Mr. Whitaker if he disagreed. Mr. Whitaker said he did. Judge Smith insisted that nothing about this involves, in my view, Ms. Habba personally. "This is about the statutes," he said. "This is about the separation of powers. This is about an important position within the firmament of our government. This is about process."
Ladies and gentlemen, our next one we have is bum bum bum. You guys guessed it. Trump said to demand Justice Department pay him $230 million for past cases. Ladies and gentlemen, this right here is just complete bullshit and absolute nonsense. Let's get into it. I will talk to you guys after the reporting.
Trump said to demand Justice Department pay him $230 million for past cases. This article is by Devlin Barrett and Tyler Pager and read by an automated voice. President Trump is demanding that the Justice Department pay him about $230 million in compensation for the federal investigations into him, according to people familiar with the matter, who added that any settlement might ultimately be approved by senior department officials who defended him or those in his orbit. The situation has no parallel in American history, as Mr. Trump, a presidential candidate, was pursued by federal law enforcement and eventually won the election, taking over the very government that must now review his claims. It is also the starkest example yet of potential ethical conflicts created by installing the president's former lawyers atop the Justice Department. Mr. Trump submitted complaints through an administrative claim process that often is the precursor to lawsuits. The first claim, lodged in late 2023, seeks damages for a number of purported violations of his rights, including the FBI and special counsel investigation into Russian election tampering and possible connections to the 2016 Trump campaign, according to people familiar with the matter. They spoke on the condition of anonymity because the claim has not been made public. The second complaint, filed in the summer of 2024, accuses the FBI of violating Mr. Trump's privacy by searching Mar-a-Lago, his club and residence in Florida, in 2022 for classified documents. It also accuses the Justice Department of malicious prosecution in charging him with mishandling sensitive records after he left office. Lawyers said the nature of the claims posed undeniable ethics challenges. "What a travesty," said Bennett L. Gershman, an ethics professor at Pace University. "The ethical conflict is just so basic and fundamental, you don't need a law professor to explain it." He added, "And then to have people in the Justice Department decide whether his claim should be successful or not, and these are the people who serve him deciding whether he wins or loses. It's bizarre and almost too outlandish to believe." Even the president seemed to acknowledge that point in the Oval Office last week, when he alluded vaguely to the situation while standing next to the FBI director, Kash Patel, Attorney General Pam Bondi, and her deputy, Todd Blanche. According to Justice Department regulations, the Deputy Attorney General, in this case Mr. Blanche, is one of two people eligible to sign off on such a settlement. "I have a lawsuit that was doing very well, and when I became president, I said, I'm sort of suing myself. I don't know, how do you settle the lawsuit? I'll say give me X dollars, and I don't know what to do with the lawsuit," Mr. Trump said, adding, "It sort of looks bad. I'm suing myself, right? So I don't know, but that was a lawsuit that was very strong, very powerful." Administrative claims are not technically lawsuits. Such complaints are submitted first to the Justice Department on what is called a Standard Form 95, to see if a settlement can be reached without a lawsuit in federal court. If the department formally rejects such a claim or declines to act on it, a person could then sue in court. Still, that is an unlikely outcome in this instance, given that Mr. Trump is already negotiating in essence with his subordinates. Compensation is typically covered by taxpayers. Two people familiar with the president's legal claims said that he had not been paid by the federal government, but that he expected to be. The second claim accused Merrick B. Garland, then the Attorney General Christopher A. Wray, then the FBI Director, and Jack Smith, the special counsel investigating Mr. Trump at the time, of harassment intended to sway the electoral outcome. This malicious prosecution led President Trump to spend tens of millions of dollars defending the case and his reputation, the claim said. According to the Justice Department manual, settlements of claims against the department for more than $4 million must be approved by the Deputy Attorney General or Associate Attorney General, meaning the person who oversees the agency's civil division. The current Deputy Attorney General, Mr. Blanche, served as Mr. Trump's lead criminal defense lawyer and said at his confirmation hearing in February that his attorney-client relationship with the president continued. The chief of the department's civil division, Stanley Woodward, Jr., represented Mr. Trump's co-defendant, Walt Nauta, in the classified documents case. Mr. Woodward has also represented a number of other Trump aides, including Mr. Patel, in investigations related to Mr. Trump or the Capitol riot on January 6, 2021. A White House spokeswoman referred questions to the Justice Department, asked if either of those top officials would recuse or have been recused from overseeing the possible settlement with Mr. Trump. A Justice Department spokesman, Chad Gilmartin, said, "In any circumstance, all officials at the Department of Justice follow the guidance of career ethics officials." In July, Ms. Bondi fired the agency's top ethics advisor. Mr. Trump famously hates recusals. He complained bitterly after his first Attorney General, Jeff Sessions, withdrew from overseeing the Russia investigation that is now the subject of one of his demands for money. "The Attorney General made a terrible mistake when he did this, and when he recused himself," Mr. Trump said in 2018, "he should have certainly let us know if he was going to recuse himself, and we would have put a different Attorney General in." The Justice Department does not specifically require a public announcement of settlements made for administrative claims before they become lawsuits. If or when the Trump administration pays the president what could be hundreds of millions of dollars, there may be no immediate official declaration that it did so, according to current and former department officials. Some former officials have privately expressed misgivings that the department's leaders did not reject Mr. Trump's legal claims in the waning days of the Biden administration. It has long been standard practice for civil litigation, including lawsuits against the government, to be paused until any criminal cases around the same facts have been resolved. Alan Fewer contributed reporting.
Well then, ladies and gentlemen, this is a head scratcher and unexpected, as Donald Trump knows he's guilty but says he's not guilty. Ladies and gentlemen, he will be sorry for what he's done. As soon as he leaves office on January 20, 2020, January 20, 2028, 29. I almost said 25, but then I accidentally said 28. No, it's January 20th of 2029. Unfortunately, might be sooner with his dementia looking old ass. Ladies and gentlemen, that is going to do it for this evening's legal breaking reporting video analysis update. I'm sorry it took forever for me to start this recording and get it uploaded to you guys. I've had a pretty busy day, ladies and gentlemen. In the meantime, please look out for my next legal breaking reporting. And I look forward to talking to you guys in my next legal breaking reporting video analysis update.